Spooling up. All right, here we go. Welcome to Win the Day podcast. There's Mark Violette. He's an attorney.
Hello.
Don't hold that against him. Hope yesterday was awesome. Hope tomorrow's even better. Today we're going to talk about how to win today. Before we get into the legal things, though, I'm going to do something real quick. Yesterday we talked about the big red X. Make an X, mark off, create a chain, right? Start a chain, build on that chain, don't break the chain. I went running again last night, 3 days in a row. I got 3 X's on my damn calendar. Oh my God, my legs, my ass, my heart, my whole body. Like right now, I feel everything. My eyes hurt.
You're in what we call the Uncle Doms, the delayed onset muscle soreness, but it shows up like, I'm here to tell you, you're gonna feel it.
My God, I woke up in the night like 75 times because I'm hurting. I guess when you get older, it's harder.
Or the moral story is, if you make a change,
don't run.
It's going to hurt, but you'll get over it.
That's right.
I'm ready for the get over it part. Anyway, so I was running yesterday. What I'm doing is 1 mile. And I'm doing it in these basically laps, up and back, up and back, up and back 4 times. Okay. And I started yesterday. And I swear to God, I didn't even have feet. They're just stumps. I'm just running, right? And just shock waves from my hair. I could feel it in my hair. But I did it. And then I came back. It was a little easier coming back. And then I'm like, okay, there's 1. Then I did again. But then pretty soon I started thinking, you know what? Good job, dude. You can probably wind this up. You did a good job. And I started thinking, you know what? I'm not going to get an X. No finish, no X. Doesn't work that way. You got to finish to get the X. Put a big X on your thing, right? So I did it. I kept going. I got the X. I'm screaming, get the goddamn X. Right? People are looking at me like, what's wrong with that freak? Right? And but I did. I got the X. And if I didn't have that mentality about the red X's we were talking about, I'm not so sure I would have done it. So
good.
Today's message then was figure out what you got to do. What's your thing? And then do the damn thing, right? Get the X. Don't break the chain. Okay.
I think there's 2 types of people, though. Like some people can self-motivate. So you motivate by saying, I want that X myself.
Yep.
Another way to do it is the buddy system.
Yep.
Where
accountability.
You don't want to do it, but you know somebody else is going to show up. So you have to do it no matter whether you like it or not. So sometimes depending on your internal drive, the buddy system may be the way to go.
Good way to go too, right?
Yeah.
You want to run with me tonight?
I do not. Yeah. I play tennis.
I have the buddy system. I have like 12 personalities and we're all out there in a group. Yeah. Anyway, so that's my story. Make an X. All right. Whether it's a lead gen or whatever your thing is, eating healthy, whatever your thing is, saving money, put an X up. Every day you do it. Make an X. Start a chain and then don't break that chain. Do not break it. Okay, but Mark's here to talk legal stuff. And I'll start it off. If you have a legal question, just fire it. And we'll address it. Real estate related. Okay.
So how do we know who's online?
How do we know? We don't. They'll pop up here with questions.
Okay.
Okay. So if you have a question or something, legal wise, real estate legal wise, fire us up.
Post in the comments who all's here and where you're here from. Let us know.
Yep. So I'm going to start out. I own a piece of land. I don't own a lot in quantity. I own a residential plot. And when we bought this lot, it was subdivided into 2 lots. One is still owned by somebody else, and they're on a septic system, and their septic tank is on our lot, which is interesting. And now they are selling their lot. And my question to Mark is, how do I address this septic tank for the new buyer? We've let it go because we haven't built on it. But when we built, that septic tank's going to have to move.
Yeah. So
what's the play here for the seller and the new buyer?
Right. So some of the questions would be, are the lots big enough where you can relocate the septic tank and have a septic tank on each lot?
No. And we have sewer is now pulled to the place, so there will be no need for a septic tank any longer.
Well, it seems like that would resolve itself
They
then.
so we could just leave it. Well, I don't know. They're going to have to get on sewer. So the new owner will need to say, all right, we're going to be on sewer. We're going to get rid of the septic.
Well, when you say get rid of it, I don't know. I don't know what the process
Well,
is.
I want to get it off my land.
Whether you dig it up and actually remove it, or whether
and then move it.
if it's
What
20
they
feet
typically do is
below.
crush it. They crush it down and fill it in.
Yeah.
But if they're still going to use it, I guess they don't have to be on sewer. They can still stay on septic. But what I don't want is them to think they can stay in our lot.
So one of two things needs to happen. If you're saying you're not going to use the septic that's on my lot, then they need to be notified, obviously. And I'm assuming that's something that the seller probably never disclosed to them.
It comes to disclosure.
Right. So the buyer may be coming in not knowing this information. But
And it's a cost of like $1,500.
yeah. To what?
Get rid of the thing or to deal with the septic tank.
Okay. I have no concept, but due to inflation, that's probably about right.
Okay.
Probably used to cost $50 a year
Yeah.
ago, but now it's $1,500.
It's a union job, so it's $3,000.
Yeah. So really, you just need to take a stance on how you want to handle it. I mean, if it was me, I don't know what the result of crushing a septic is. I live in a place where we have city water, so we don't have to deal with that kind of stuff. But I mean, if it crushes it down, and it's one of those things where in reality, no matter if
But
you
it cuts them off from their plumbing.
right, but that's assuming that one, the buyer now is aware of it, and two, that they're saying we want to move to city septic anyways,
Okay.
or sewer.
So I guess my question is, do I write the seller a letter saying, please disclose to the new owner, buyer, there is a septic tank issue that will have to be resolved by them.
Yeah, I think the better way of doing it is to, and I'm assuming the seller of that lot used to own both of those
Yes.
lots who sold to you. So he's
Father did, and then two kids
Yeah.
got one each.
so he's thoroughly aware it exists and
He's
what the problem
keenly
is.
aware.
Right. So what you would do is notify him of the problem that he's already aware of. So you have something in writing.
Yeah.
And if he doesn't rectify it, what you're going to do may require some financial aspect from him, which gives him the motivation to address this. Otherwise, he's gonna be like, oh, letter in the mail. Yep. Neighbor who's never touched their lot in 5 years since they've owned it. I don't really care. I'm going to sell. I'll be gone.
So do I send it like certified mail or something?
Well, yeah, always, because you want to make sure they've received it. But the problem is then you have the what if. What if he just crumples it up and throws it in the fire
At least
pit?
I did my part.
Well, it doesn't resolve the problem, though, because now a buyer's going to come in not knowing, and then everybody's got to hire attorneys. That's going to cost a lot more than a $1,500, hey, let's figure this out now kind of situation.
All right. So I'm clear. I write them a letter and say, hey, remember this thing has to be dealt with.
Give them a time frame.
Yeah, it's notice.
Yeah.
All right.
So basically, I mean, what I normally do is, depending on how difficult the situation is, you use 10 days or 30 days. If I don't hear from you in 10 days, I'll presume you're not going to do anything. And here's what I'm going to do.
Okay.
So basically, you're telling them,
Well, they called me to tell me they were doing this.
well, that's good.
Yeah. So I think they are aware.
How far is the property?
How far away, like
Yeah.
from physically here?
Yeah.
40 miles.
All right. So I'd hop in my car and drive over there and talk to them first.
You want to do that?
No, if I was the owner next door, I would hop in my car and go talk to him.
Okay. Fair enough.
Yeah.
Fair enough. Or I'll call them on the phone even.
Yeah.
Okay. Here, now I got part two to that question. The neighbor across the street from said lot is building a house. He calls me up and he says, we want to use your lot as a staging ground for our building. We want to put materials and stuff there. Do I need to put some sort of hold harmless together? How does that play out?
I always say good, better, best. So the best thing to do is have something in writing, because if they're putting materials there,
And I'm willing to do it.
right? If somebody steals all their stuff,
Yeah, what they steal.
if a hurricane comes and destroys it all, if a fire occurs,
Somebody slips and falls.
if somebody's cigarette gets thrown out the window on your lot that you haven't mowed in a month and the weeds are dry and it burns all their stuff, guess who's going to get sued? Because you
Okay.
probably have insurance on your vacant lots. So there needs to be something drawn up that he's 100% at risk, blah, 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 one of those kind of documents.
Okay.
Because what the likely things that's going to happen is the stuff will get damaged or somebody will trip and fall or get injured. Both of those, you get sued against your insurance policy. And then every time you apply for insurance, have you ever made a claim against your insurance policy? Yes, I have.
I don't think I have insurance on the lot. Do I have,
Well, then you get sued individually, or the owner of the lot does.
Why would I have insurance on the lot? Does anybody ever have insurance on vacant land?
Who's the owner of the lot?
Me and my partner.
Individually or in an LLC?
Both.
Yeah, then get insurance.
Yeah, somebody could step in a hole, break their ankle, and
Yep, you get sued.
And I could sue them for being on my lot.
You
Can I
can.
sit out there in a lawn chair with a gun and protect my castle?
Let me ask you this: how much do you think the cost of liability insurance on vacant lot is?
I don't know. The insurance is
How
bad.
much do you think it
news.
costs to hire an attorney to defend somebody stepping in the hole
Oh,
and suing
damn
you?
attorneys. And it's a
Yeah.
choice between insurance guy and attorney guy.
That's correct.
Oh, my Lord.
Yep.
I saw one of
Cumberland.
these billboards with an attorney who was saying, "Have you broken your leg on John Moran's lot?"
Yeah.
Call me. Yeah.
I'm going to go over. There's going to be this big crowd trying to twist ankles. Oh, my Lord. Okay. So those are my two questions. So get something in writing from both.
It's basically a hold harmless and indemnification agreement for the lot.
Okay. I'm probably going to talk to you afterwards.
Yeah.
Okay,
I
cool.
got a question.
Yep.
I've been talking with a buyer about the best way to set up for when his mother is buying a home. When she passes, what is the best way to have everything set up for him as far as inheritance or a trust? What would you suggest?
That is such an open-ended question because a lot of it just depends on what assets they have.
Okay.
If they're loaded with money, then traditionally you're going to set up what's called a trust.
Okay.
And you're going to move all of your assets into the trust. And the reason for that is when the mother passes away, all the assets are in the trust. So there is no probate. You don't have to go to you don't have to hire an attorney. You don't have to go to court. You don't need a judge.
Very important.
Correct. However, with that being said, a lot of times people think they fully, what we call funded the trust, like bank accounts, insurance policies. Sometimes those get overlooked.
Mhm.
So let's assume they had an insurance policy or a bank account that just had her name on it and it wasn't moved into the trust.
Mhm.
Then you're still going to have to open a probate because when a person passes away, let's just assume they're an individual. If they pass away, anything they own individually, there's no one in the world at that moment in time that has the ability to legally deal with that asset.
Mhm.
I know the son's going to say, I'm the sole heir and I've seen her will and it says I get everything. So don't worry about all the legal stuff. I'm okay to sign stuff. And that's not true.
Mhm.
So if you're an individual and you pass away and it's not already set up that it passes outside of probate, then whoever your heir is, usually the will notify or indicate a personal. In Florida, we have personal representative. It's also known as an executor in different states, but it's a personal representative. So the will gets filed with the court. And of course, in order to do that, you have to hire an attorney. So son goes and hires an attorney who takes the will and other stuff and files something with the court, which is expensive. And then at some point, the judge will sign an order appointing the personal representative. Once the personal representative gets appointed, now they are a legal entity that has the authority to deal with banks, insurance companies, the DMV, you name it.
Mhm.
But there's a time delay, usually a couple months at a minimum.
But doing all this in advance is easy. Is that fair to say?
Well, you can set up, like we were talking about, you can set up a trust in advance, and then you don't have to worry about this as long as you've done everything correctly, which I find most people don't. They hear it, but then they don't do it.
That's right.
Yeah,
Find an estate planning person and they'll get that set up for you real easy.
correct.
Yeah.
Like Bill Kilpatrick here in
Very
the
good.
Destin area
Very good.
is a good one to use if that's the case. Now, let's assume the mother has no money and the only thing they have is the house.
Okay.
There is this thing called a ladybird deed.
Yes.
And what that basically is going to say is upon my passing, then you have a grantee beneficiary listed in the deed, then it automatically transfers to that person. We call it by operation of law, which means you don't have to do anything else. And one of the main things that Florida has, and I don't know about the other 49 states, but we have, if you're a husband and wife and the deed goes into you as husband and wife, the benefit of that is if the husband passes away, we call it by operation of law, 100% of their interest in that property automatically goes to the surviving spouse if it says husband and wife. So what we're seeing these days are a lot of probates. So the listing agent and this is one of the things I was going to talk about today. When the listing agent goes to a listing appointment and realizes because they pulled the deed into husband and wife, and they meet with just the wife, and you go, where's the husband? Oh, he's dead. Okay.
He's in the urn.
Yeah.
Yes.
He's on the shelf.
Yeah.
So he can't sign something if he's on the shelf, but red flags should go off, because what you should automatically think is, we have probably a title issue to deal with that will delay closing. What steps need to be done now while I'm meeting with you in a listing appointment? Not once we get under contract, not after I've spent 3 months marketing and doing everything. What needs to be done
Or
right
it's under
now?
contract and the bank has a rate lock or any number of bad things or good time issues.
So it's always useful to call me or address that with me, because sometimes, as Jeff will tell you, my favorite thing is it depends. So you can't just go, husband's dead, what do we need to do? I'm going to say, well, it depends. Does the deed say husband and wife? Were they continuously married? Did they separate? You know, is it their homestead, non-homestead? So some of it depends. And some of it's as simple as, not a problem. We just need a certified copy of the death certificate. And as long as the wife signs an affidavit saying they've been continuously married from the day that they took title to the time that he passed away, then we're golden and nothing else needs to happen. But let's assume whoever did the title into them, it doesn't necessarily reference husband and wife, or you find out, well, they were separated or they were divorced and still living together or something like that. That would be unusual, but that would change.
Divorced and still living together.
Right. Well,
Never know.
sometimes you think the grass is greener only to find out that your pasture was okay. But
Listen to the philosopher over here.
or that nobody on the other side, never mind. I was going to say doesn't want to eat your grass, but that's probably a bad analogy. So, sorry. But you,
Right,
so you could see it depends on the situation. But so when you ask me what's the best thing for him to do, the best thing for him to do is to call a wills, trust, and probate attorney.
Okay.
Because that attorney is going to get all of the mom's assets and say, here is the good, better, best way to do it under her financial situation. And like I said, if she only owns the house, then I'm going to say the Ladybird deed is sufficient if that's their only concern.
And earlier in the process, the better.
Got it.
Okay, so Olivia Victor has a question. Are there any special rules to follow when performing a 1031 exchange with a property that's in another country? I haven't considered another country.
You can't do 1031s from another country. You can only do the 50 states and Puerto Rico.
Not even Virgin Islands, huh?
Not even California?
Those are British Virgin Islands.
Ah, that's right. Well, there's US Virgin Islands.
Now, I will tell you, I probably have not looked this up in a year or two, so maybe something has changed. But as far as I know, it's the 50 states plus Puerto Rico.
Okay. So that's a good question. If somebody wants to do 1031 from the U.S. to Canada or otherwise, where?
Can't do it.
And you can't, and there's not an in version of that either, is there?
And the reason there is nothing is because our government wants their money. So if there is a potential tax liability because you made money in the U.S., now you're going to take that money outside of the country. They're going to lose control over getting their money, and they certainly don't like that. That's why they don't allow it, as far as I know.
Fair enough. Fair enough. It's a tax thing. It's a U.S. tax thing. Here, I got a question for you. Buyer broker agreement. If you're working, this came up. We have a listing. A buyer wants to buy our listing. Of course, they don't want to pay a buyer's agent. They want to take the money either out of the sale price or out of the sale price.
Or
right?
get credit.
Some sort of version of that.
Yeah.
Okay. So do you need, here's the way it works all the time from my standpoint, listing agent. The person buying doesn't want to pay a buyer's agent, but they want me to somehow represent both sides and pay them the buyer side, right? And the credit or whatever. To which I say, no, I'm not going to do that. I'll lower it down and take less if I have both sides, but I can't represent you. And normally what we would do is we'd say, okay, here's a document or whatever. It says you're on your own, right? I'm not representing you in any form or fashion, right? So now with the whole new rules and everything, Are we only representing the seller? Is there a buyer broker? I'm confused.
So the answer is I don't know, because eCar is going to have to come out with a stance on that situation. Because right now, even if you're the listing agent, you're not supposed to open up the property to somebody unless they're under a written agreement. So I don't know if Mark, do you know, has eCar or NAR taken a position on a listing agent opening up the property to a buyer who's not represented?
So yes, in that situation, you're representing the seller, and you are showing the property on behalf of the seller. Now, if they want to go and look at some other property, that's where the buyer brokerage agreement is required at that point. But in the whether
so, do you need a non-rep agreement then at that point? Say, hey, you're on your own.
No, it would be the same equivalent of you are hosting an open house and somebody comes into the open house. You're working on behalf of the seller. And of course you can show. Now, the moment you start discussing or moving in the direction of showing them other properties, that's when an agreement must be entered into. But otherwise you're working, the agent who is doing the open house is working as a sub-agent of the listing agent, and the listing agent is working on behalf of the seller by showing the property to this customer.
Right. See, and that sounds all good in theory until the buyer says, well, gee, John, I don't have a contract. Can you fill out the contract and here are my terms? And okay, well, do you want to do an inspection? And
Which is what they always do.
And now you're asking questions to them. Well, do you think I need an inspection?
At that point,
yeah,
one has to enter into some kind of agreement. And my thought is you either, once again, like John said, state there is no representation, or there is a fee for this service provided.
Okay, so let me ask you this then. You get a commission agreement that says if Joe Blow buys this property in this time frame, XYZ realtor or brokerage earns X amount at closing. Commission agreement. Okay. Do you need a buyer broker with a commission agreement?
I'm not following the question.
All right. So buyer says, I don't need you.
Right. For the buyer to receive the credit, do you need a buyer broker agreement?
Yeah, I mean,
so in the past,
I'm representing the seller.
Right. So in the past, it used to be you don't put commissions in the contract period.
Right.
Now they've obliterated that rule. So I
So
think
you do put them in the contract?
I think the better way of doing it would be put in the additional provisions, because whatever makes it clear is what I always say is the better way of doing it.
Because it's not going to be in the MLS anymore.
So it would basically say seller gives X% as a concession to buyer,
right,
to be used for and
or however they want to do it. Yeah,
but you don't need a signed buyer broker agreement.
I would think so.
Okay.
No, and I think a non-rep, I don't know what the language inside of a non-rep agreement actually looks like, but if it says I don't represent you, period, then if a buyer calls you up and says I don't want an agent and I want to see your listings, I think you're better off presenting that to them. They may say, I'm not signing anything. I don't know what this says. I'm not an attorney. I'm not going to sign anything. But at least you'll have some track record of you attempted to get them to sign it.
Yeah, and to have them sign across the bottom.
Will not sign.
Will not sign.
Yeah, refuse to sign. Or
but
something.
I think more and more what we're going to see in those additional terms is seller to make concession, because whether it's going towards the buyer brokerage or a reduction, I think the simple thing is if it's not going, it's not a concession because there's not a buyer broker on the other side. It's just going to be a reduction of the price of that percentage. So,
but sometimes the buyer has a lender. If you reduce the price, then they're still only going to get 80% of the reduced price. They want the higher price plus the credit because it helps offset their closing costs.
Could be, yeah. And so those are things, but we're going to see that all in the additional terms unless FARBAR updates the contract for something specific to commission concessions.
Yeah, and I think if usually the buyer's looking for a credit, that the sales price, whatever, the seller's looking for a net amount, whether they call it seller concession, reduction of price, credit, blah, 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 whatever. I don't think it really matters as long as the listing agent can present to the seller what the buyer's really looking for. Yeah. No, they want their 2% commission because they want to pay less closing costs. You're going to net this amount. Is that good for you? I mean, I think in reality, that's how it works out. And the seller is either going to go yes or no.
Yeah.
Okay.
But just remember, the buyer has a lender. Sometimes the lender's going to say, we can't give you 10,000 in seller concessions or credits or whatever. So you got to be aware, is the buyer using VA, FHA, rural housing, conventional, paying cash, those kind of things.
Yeah. What's the limit for concessions by the lender? That's
Right.
got to be explored. Wait, do buyers ever not run things past their lenders? And
Well, they do, especially when they're online, because they saw the great rate and the email that they received already said they're approved.
Yeah.
All right, Jeff, you got anything?
There's so much more to all what you're talking about
Mhm.
and like Mark said, the first statement was people are going to have to come out, ECAR, and set precedences on representation. And then for me, it'd be errors and omissions insurance. Where does that fall? If you're a non-rep, are you actually legally accountable for what they do? There's a lot to what you guys are saying. So
Jeff, if you have a non-rep, but you act as if you are repping, you've crossed over the threshold there. So
yeah, it's if you act like a duck and walk like a duck, you're going to get treated in court like one too, right? Regardless of what that paper says. So be careful with all of that. And then you're assumed transaction broker, John.
Yeah, right from the start.
You're assumed transaction broker in the state of Florida unless you stipulate otherwise, right? So you could.
But our listing agreements do stipulate otherwise.
Until the 17th of August, I guess. Maybe it'll.
Oh, you think that'll change? There, you won't.
Maybe.
Oh, for God's sake.
well,
Maybe. Who knows? Someone's got to make a stand on this, right? It hasn't been stipulated in detail, has it, Mark?
No, what you can say is NAR and ECAR has not run that first mile yet, so the pain hasn't started.
I did it for them.
Boom, boom.
well, and I do think that we're going to have some, if we've got listings on the MLS post August 17th that have not been updated to reflect that we are not offering on the MLS this co-broker percentage. Those are going to have to be revisited and updated. Otherwise, we're in breach because we're not
Right.
having what we agreed it for. So a lot's going to happen in the next month, 2 months, basically, from today.
Yes.
What's all?
Question.
Good info. Thank you for the info. We answered that's at 10:31.
Okay.
All right, we're at the point where we need to wrap this up so we can go make some red X's. Okay. See y'all tomorrow. Bye.
Bye.
Bye.